In the lectures on judicial activism and restraint, we discussed the role of the Supreme Court in American democracy from a theoretical perspective. In this lecture, we're going to discuss it from a more practical perspective. What we're going to be talking about essentially is the same thing we talked about in the activism and restraint lectures, and that is the relative merits of the courts as opposed to the legislature when it comes to making public policy. What is their proper role? But whereas the other lectures focus on political theory and constitutional law, in this case we're just asking a simple question. Which branch of government makes better public policy? Which one does a better job? And everything in this lecture is taken from a significant book, Donald Horowitz's The Courts and Social Policy. And so what I'm going to be doing is introducing Horowitz's argument and then making a few brief comments of analysis. So Horowitz makes 5 specific criticisms of adjudication. He says that there are 5 problems with making law through lawsuits. So let me introduce those 5 problems and then we'll talk about each of them in turn. First, adjudication is focused on rights and duties. Second, it's piecemeal. Third, adjudication contains no provision for policy review. Fourth, it's poorly equipped for finding social facts. And finally, it's reactive. So let's take a look at each of those. First of all, adjudication, according to Horowitz, is focused on rights and duties. And certainly there's a lot of truth to this. When we think about the courts, we think about the right to free speech, the right to freedom of religion, the right to privacy. And the problem, according to Horowitz, is that rights and duties tend to be absolute. If somebody has a right to something, then the government has to make sure that right is honored regardless of the cost and regardless of the consequences. And duties tend to also be absolute. And as a result, since the courts focus so much on rights and duties, this tends to discourage a balancing of interests. That in some public policy areas, there are different rights, there are different duties, and it's difficult to balance those things in a courtroom setting. For example, abortion, conservatives certainly, but Horowitz would point to the 1973 Roe v. Wade decision because it said that women have a right to an abortion, essentially absolute right to an abortion in the first 3 months and an almost absolute right to an abortion in the next 3 months. And as a result, there was no compromise. There were no regulations that were permitted, and as we've already mentioned, this led to a significant amount of the political conflict we're experiencing today. The idea is that when legislatures deal with abortion, they can be more nuanced, perhaps allowing certain restrictions, but without banning it altogether. Another example would be guns. The Supreme Court, of course, has said that Americans do have a constitutional right to bear arms, an individual right to bear arms. It's unclear at this point how far that right will extend, but it's possible that if the court takes an extremist view with the right to bear arms, that even reasonable restrictions, such as waiting periods, will be struck down by the court. Another example that we're seeing right now are the lawsuits to force states to open back up as a result of the coronavirus shutdowns. And of course, they're claiming that their due process rights have been violated, and if they win, of course, then there's no balancing of interests. The floodgates will be open, and everyone will have the consequences of their successful lawsuit, if indeed it is successful. So The legislature, according to courts, and the executive branch tend to do these things better. That they are able to make more nuanced judgments and are able to balance various interests because they are not as focused on rights and duties. Horowitz also says that it's problematic that adjudication is piecemeal. What does that mean? Well, what that means is, of course, that lawsuits involve individual litigants. A lawsuit is brought by a company or a person or an institution, but the case focuses on one specific dispute, and it focuses on certain specific legal issues, and it considers those things in isolation. And you have many cases that are considered in isolation from each other. And Horowitz says that this isolates artificially what in the real world is merged. What this means is that basically the courts can't see the forest for the trees. The courts rarely have the ability to look at the big picture, and they're rarely able to examine the trade-offs that might be involved and the consequences of their decisions. For example, one area in which courts are criticized have to do with special education. There are obviously children with special needs in K through 12 education, and they are often very expensive to educate. And as a result of some court decisions, some critics argue that too much money is being spent on special education to the detriment of students who are not in special education. Now, whether this is true or not, I have absolutely no idea, but the argument that Horowitz is making is that legislatures can examine that question and figure out what the trade-off should be and what that right balance should be, whereas the courts, simply looking at the needs of the special education children, don't see the big picture. Another example that's often cited is the Americans with Disabilities Act, and that strict enforcement of the ADA requires that some businesses and some services not be offered at all because the cost of ADA compliance is too heavy, thereby depriving everybody of the service, and that nobody is served by such strict enforcement. So these are the kinds of things that Horowitz would point to as problematic with adjudication. And of course, he says Congress is better at making these trade-offs. They can pass laws that tackle different subjects at the same time, that take into account varying situations, and so policy making should, when possible, be left up to the legislature. Horowitz also argues that courts contain no provision for policy review. And he is right, as we mentioned in an earlier lecture. Courts have few mechanisms for ongoing review of how well their decisions are being implemented. The courts typically make a decision, and they have to rely on others to implement it. And in order to find out whether their decisions are being implemented or not, they have to wait for additional lawsuits. And of course, if we're talking about the Supreme Court, they only hear 70 to 75 cases a year. So the number of amount of attention they can pay to decisions that they've already decided is limited. And as a result, it's very hard for courts to determine both whether or not their decisions are being complied with and being implemented, but also whether or not they're effective. Maybe their decision is being implemented, but maybe it's just not working as the court thinks it should be. Well, there's almost no way for the court to find that, or at least to find it very effectively. Now, Horowitz, once again, says Congress and the executive branch, but specifically Congress and the legislature, is much better with regard to policy review. They can follow up, and they hold hearings, and that they have staff who are equipped to monitor this, and of course they work with executive branch agencies who implement these laws, and therefore Congress is in a much better position than the courts to make public policy. In addition, Horowitz says that courts are poorly equipped for finding social facts. And here, Horowitz makes a distinction between two different kinds of facts: social facts and historical facts. Historical facts are what you probably think of as general facts. They're probably what you'd read about in a history book. Historical facts are specific events. They're specific things that occurred. And courts are very, very good at determining historical facts, figuring out what happened. They have witnesses called who can be compelled to testify in most instances. They are put under cross-examination, so on and so forth. And historical facts would include things like, did Mr. Jones shoot his wife? Did a company sell a defective product? So courts are very good at finding historical facts. But what are social facts? Social facts are bigger trends, larger trends, explanations for why things occur, correlations between different events. So for example, social facts would include things like, what are the causes of gun violence? Now, if you're going to legislate or if you're going to make policy about gun violence, it would be good to know these things, but courts are not good at knowing these things. Does the death penalty deter crime? That's an important issue. Whether or not the death penalty deters crime is a fact, but it's not a fact that the courts are good at determining. Another example of a social fact: do increased taxes reduce economic growth? Courts often do things that require the government to spend more money, might require them to raise taxes. What effect will that have on the economy? Well, the courts have very little way to figure this out. And that's because in courts, the role of expertise is limited and confusing. First of all, it's limited because the only place that experts appear is at the trial court level. So experts don't appear before the Supreme Court. The Supreme Court only relies on whatever was said at the trial court. And it's confusing because often, even at the trial court level, you have experts on both sides. And one of them will say one thing, the other will say the other thing, and of course, as we've mentioned, judges are not scientists, and so they have difficulty figuring this stuff out. And in fact, as I've mentioned, in Brown v. Board of Education, the court cited some social science studies, and they were criticized for that. One of the very few times they actually drew upon scientific expertise, they were open to criticism that was an inappropriate thing for them to do. So courts cannot do this very well. On the other hand, says Horowitz, Congress is much better at finding social facts, the essential facts that you need to inform any decision you'd make about public policy. And that's because Congress has investigatory powers, as we've mentioned. They can subpoena witnesses, and staff members become experts. They have accountants and others that they can call upon, and so they can actually dig into the weeds and determine these important social facts. Finally, Horowitz says that courts are problematic because they are reactive. Courts can't do anything at all until litigants call. So if there's a social problem out there, unless somebody files a lawsuit, the courts can't do anything about it. Congress, on the other hand, can. If it sees a problem, somebody can introduce a bill and it can enact that bill into law. Courts, on the other hand, not only cannot act until litigants call, they have to act when litigants call. So they are forced to make policy even when the case is unusual or weird. And of course, they have no way of knowing whether a case is unusual or weird. This is important because when the courts decide a case, of course, they are setting a precedent for the future. But if the case that they are deciding is not a typical one, if it's an unusual case, then perhaps the decision that they reach or the principle that they formulate will not really be applicable or workable in most cases. There's a famous maxim in the law that says hard cases make bad law. And this was even more clearly articulated by Justice Oliver Wendell Holmes, who said, "Great cases, like hard cases, make bad law. For great cases are called great not by reason of their importance, but because of some accident of immediate overwhelming interest which appeals to the feelings and distorts the judgment." So, using individual cases to make public policy may not be the most effective way of making public policy. Now, these are Horowitz's argument, and of course there's some truth to most of the things that he says with regard to the court's deficiencies. But I believe he completely overstates things when it comes to Congress's capacity. Horowitz's picture is a picture of a Congress that is rational, that is conducting hearings and making decisions based on scientific evidence, and is conducting regular oversight and fixing laws when they go wrong. And of course, Horowitz's book was written long ago, but even then, this overstated the policy-making capacity of Congress, and things have gotten even worse since. If congressional hearings are often shams. Although experts may be called to testify, they're usually called to please the majority. And often congressional hearings are not well attended, and so nobody even hears that stuff. And in any case, of course, the high level of partisanship in Washington now means that almost every decision is decided solely on the basis of political party rather than on whether the law is effective or rational or working well. And as far as the focus on rights and duties, of course, sometimes that's important. Sometimes you can't compromise on things. And some things, of course, were put into the Constitution specifically so they wouldn't be compromised on for other interests such as economy or efficiency. And so I think everybody recognizes the partisan polarization that characterizes Congress, and that the legislation it produces is far from ideal. And therefore, again, although I think that he makes some valid criticisms of adjudication, his analysis of legislation is unrealistic and overly rosy.